Started here. Okay, everybody? We good? Yes, sir. Senator Watson, okay. So what we're going to do is you have two lists in front of you. We've got voting list number 25, which is long. There's one bill on voting list 26, which is an emergency bill, and JPR is second, and so this is an important bill. So we're going to go just to that one vote, that one bill on voting list number 26. And so with that, Stacy, again, we're on House Bill 1341, which is on list 26.
House Bill 1341, Immigration Enforcement, Expanding Sensitive Locations, Notification and Guidance, the Maryland Values Act of 2026. This emergency bill requires public school personnel to notify the county superintendent of an affected school or the county superintendent's designee if the school personnel is notified of immigration enforcement in a sensitive location that includes a school. It's a very long recitation. This is similar to Senate Bill 810 as passed by the Senate. There's an amendments in the packet there, as you can see. These amendments would conform the bill to Senate Bill 810 as passed by the Senate, and it adds one additional amendment that is in agreement with the House, and that requires each courthouse on or before October 1, 2026, to implement a policy that may consider the guidance issued by the Attorney General under this section, and requires each courthouse to update their policy on or before October 1 of each year as necessary.
Okay, questions for Stacy? It's a bit of an agreement, a consensus between the chambers. Okay, anybody want to move the amendments?
Move the amendments.
Okay, a motion from Senator Harris, second from Senator Washington. All in favor of the amendments to House Bill 1341, raise your hand. All opposed? Amendments carry. House Bill 1341, as amended, is in front of us. Senator Harris moves the bill favorable as amended. Is there a second from Senator Washington? Okay, further discussion? All in favor of House Bill 1341, raise your hand. Okay, anybody opposed? Okay, we have one dissenting vote, red vote from Senator Carrozza. You have that marked? So the bill does pass. Okay, now let's go to voting list number 25. Okay, where we left things on the hunting bill was we had accepted, I think, 3 Hester amendments, as I recall. We had lengthy conversation about Senator Bailey's amendment. And he has withdrawn that amendment. So we do not have Senator Bailey's amendment now. And so we don't have to discuss that. We do have one additional amendment from Senator Washington, as I understand. And so April can describe it, and then Senator Washington can weigh in. And I think that's the only further amendment on the bill offered, and then we can consider it. I would make the note that generally the bill that came out of the House, which for the most part is what we have in front of us, did pass the House of Delegates 131-6. So there wasn't any kind of party line thing. Okay, with that, just on the Senator Washington amendment, April?
All right, so just to refresh your memories, House Bill 1063, Natural Resources Hunting Management, allows DNR to authorize the reduction of deer populations on any single contiguous property of at least 10 acres where it is documented deer damage under the new deer damage permit, modify Sunday hunting hour restrictions in specified counties, and for a 3-year period beginning July 1st, 2027 and ending June 30th, 2030, repeals the existing county-specific hunting authorizations and requires the department to adopt regulations allowing for Sunday hunting. The amendments that we adopted, or the committee adopted last Thursday, are in the bill packet on pages 67 through 68, reprint beginning on page 70. These amendments prohibit DNR from authorizing Sunday hunting under the newly established deer management permit in Baltimore City, Baltimore County, Howard County, or Prince George's County, requires DNR to establish a process for counties to request changes to Sunday hunting regulations that apply to that county, and expands reporting requirements under the bill as specified. Additionally, Senator Washington is offering an amendment that appears on page 86A of the voting packet. With the reprint language is on the following page. Senator Washington's amendment would limit the expansion of Sunday hunting during the bow season in Baltimore City to 1 Sunday per month and only on private property subject to applicable safety zones.
Okay, so this is just involving Baltimore City and nobody else? Okay.
Yeah, well,
Yeah.
so with, consistent with the rest of the code, there are, the statement, it's making it very consistent to what some other jurisdictions have with regard to the time. Is that one as well?
Oh, yeah.
Private property. And so it was the understanding that it was just private property, but when I looked at the section of the code, it didn't really stipulate that it's only private property in Baltimore City. And so that's what this bill is. But also, similar to what Baltimore County, Howard County, and Prince George's County did, it allowed for the exceptions to that rule, that there could be some instances. Oh, seriously?
Okay.
Did we get it with the other
Oh,
ones?
no, it's fine. Okay, so anything else you want to add to what Senator Washington had said?
No,
Okay.
just she's correct that it also includes that time limit. So
Okay.
Sunday hunting,
Okay,
bow hunting would be limited 30 minutes before sunrise until 10:30 a.m. and from 3 p.m. until sunset.
okay, just on the Washington amendment, okay, well, Senator Washington, you want to move your amendment so we can
Yes.
get a discussion going?
Move the amendment?
Okay, is there a second on the Washington amendment pertaining, okay, we have Senator Harris. Second, okay, Senator Carrozza, just on the Washington amendment, not on the underlying bill.
So is this amendment, and I guess I'm going back to, because it's been kind of threading a needle with this overall Sunday hunting bill. We're working off of amendments that we passed earlier in this committee that aren't on the House bill that came over. These are the ones that we're adding. Correct. And then this is an additional, and I guess I wanted to ask, just given the challenges with this bill, if the councils have been talking to each other to know that, are these going to present, these amendments are going to present challenges to get it through. We focused on the one issue, which has been, the one amendment has been removed by Senator Bailey. That seemed to be a focus there, but then these other amendments that we're adding in this one, I just want to make sure that, has there been any coordination?
There has not on these amendments. I will say these amendments are specific to Baltimore City. So.
This one that we're.
Right, this one. The ones that, the previous ones previously adopted by the committee, offered by Senator Hester, at least the conversations with DNR have been supportive. It's largely sort of clarifying and sort of strengthening some reporting requirements. But no,
Were those the
there has
ones,
not been
those were
coordination.
the other exceptions of the county opt-outs?
Correct. Of the deer damage permits.
Can we, I think we have no indication that the Hester amendments that got on here, potentially even this one amendment dealing with Baltimore City, are material to derail the bill, if that's what you're asking
No,
on the
I
House
guess-
side, or what?
Well, we're picking, we did so many amendments last week, so I was trying to pick up on making sure that I understood the base bill, so maybe after we talk about this, and from conversations when we had DNR, they gave the impression that there was still county flexibility with the underlying bill. I wanted to, number one, understand, again, we're picking it up after, several days here, make sure we all understood the base bill, okay, whatever, the Sunday hunting affecting deer, what the hours are, the amendments that we already passed, which apparently seem to be okay with the department, and now we're adding this. And I keep coming back to at least the way it was presented last time, is that individual counties could work with the department to customize their Sunday hunting. So for instance, with the 3 counties I represent, I 2 of the 3, I think, would probably want to maximize every provision, and one of my counties would probably want to make some adjustment on timing. So that's what I think it's important, just to clarify that, make sure that I want to make sure I have the base understanding of the bill. And then as we're adding these amendments, ones that have already been added and new ones that we're adding, that, we don't jeopardize whatever that core, the core bill that's already been worked through the House.
Okay, well, Mr. Petito, you can come back up here again. Again, we did have a lot of discussion, but while we're no, I understand. Again, I thought the main thing was the Bailey Amendment. Clearly, it may have been an erroneous assumption now that there is no Bailey Amendment, but okay, can I get Senator Attar involved here as well, just in the conversation?
Thank you, Mr. So this is the first time I'm seeing this amendment. I know I was out a couple days, so maybe I missed it ahead of time. But the sponsor of this House bill is a delegate from Baltimore City, and I reached out to her as well. She does not support this amendment, and the city administration of Baltimore, they actually supported both Sunday hunting bills. They wanted every Sunday. So I'm going to oppose this amendment.
Okay, well, then I guess this isn't as simple as I thought it was going to be. Okay, Senator Washington.
So upon reading the entire resource article, there were some assumptions in my conversations with the sponsor, where she said that it specifically says, not on that it's only private property. There were just a number of things that turn out to not actually be in code. And so the provision that simply very broadly states that the department may authorize hunting in Baltimore City is really broad and does not have some of the stipulations that are in other jurisdictions. So that is part of, that is why I believe we need to have that. Happy to, if that's a problem, I'll make it a floor amendment, but the committee can either vote. This is not a delegation bill, right? There was a delegation bill. It doesn't supersede the delegation bill. So whatever is in there about Sunday hunting is still the case. Because specifically, one of the amendments does say except for as authorized under 4-101, where it says you can do some of that. So can we wait and talk some more?
Okay, well, let's because if we're going to
I guess my point is that I'm here, or we're here, to ensure that that when we're making decisions about what is or is not in legislation, that it is accurate. And so the specific protections or prohibitions on private property, or even some, just don't exist.
Okay, Senator Harris.
Yeah, I appreciate it, Mr. Chair. I'm sorry, I probably missed it. And what made me take a look at is when Senator Attar made it. Do we have is there a letter from the delegation for this? That should solve it right there, right?
Okay, Senator Attar.
Did have a letter for another bill that would allow Sunday hunting in Baltimore City, excluding District 43A and for archery. Yes, yes.
This is, yes, this provision is just for archery.
This provision is. So the letter that we had was for Baltimore City excluding District 43A, correct?
Correct, which is not in this bill.
It is. That is what that provision is. It's just
Here?
archery.
No, but does it address this? Does it address this section of the code?
So for Baltimore City,
Right.
So the bill as it came over from the House folded in the archery bill, the archery hunting bill that had been a delegation bill, a standalone delegation bill. That was a decision in the House, was to fold in a couple of the county-specific Sunday hunting bills, including that Baltimore City bill. The bill, in general, does not authorize DNR to allow additional Sunday hunting in Baltimore City outside of that narrow exception for bow hunting as was requested in that bill. Generally, Baltimore City is just out of this bill.
All right, so on, just I need some, just
Okay.
a couple minutes and
Okay,
if I
'cause we
can't
have a
resolve
long
it,
list
I'll
here,
pull it.
Senator Washington.
I understand. So on the first page of the bill, it says may not, so this would be page 71. Okay. So this is about the method of reducing deer population, right? And it says may not authorize hunting on Sundays in Baltimore. And Baltimore County, Howard County, and Prince George's County. So is that correct?
That is correct. So
All right.
that is the new, so that's one of the things that this bill does.
Right.
So just to, there's kind of two buckets of what this bill does. Well, maybe three. The first one is it creates this new deer damage permit that generally, much like there's an existing deer management permit, where if you were a farmer and you get this deer management permit, you typically you can hunt on your property on Sundays. So that's existing. This creates this new one that's a little bit broader than the deer, that sometimes called the crop permit, the deer management permit. This creates this new permit, but says basically this new permit cannot be used to authorize Sunday hunting in Baltimore City, Baltimore County, Howard County, or Prince George's County.
Correct.
So that's one bucket.
Right. And just to say, so our local bill did not address that at all.
Correct.
That is correct, okay. So then it talks about maps, et cetera, and it talks about some things. And then there's a broad statement. Okay. So on page
Okay,
75.
Senator Washington, I'm
just-
sorry.
yeah, yeah.
There's a dispute clearly within the Baltimore City
No,
delegation.
there's a-
Apparently, I mean, the sponsor from Baltimore City
The
is
sponsor
opposed to
of
this.
what?
We don't have a delegation letter. I'm going to hold the bill. We got to work this out. I mean, we can't spend 25 minutes or 30 minutes trying to sort through the
I'm
Baltimore
not
City
trying to
matter.
sort through, I am trying to understand the bill. We have a colleague also that wants to understand the bill, while I'm going through sections, trying to understand what each section says. And so, one of the new provisions is it talks about that there is allowed to have deer hunting, in Baltimore City. And then we passed an amendment that provided for exemptions for Baltimore County, and this is on 75, Baltimore County, Howard County, Prince George's County. And each of those delegations got a letter from their delegation to add those?
So all right, we're on page
Yeah,
75.
yeah.
All right, so this part up here, the lines 4 through 5, that's the language that was pulled in from this originally standalone Sunday hunting, Baltimore City, just bow hunting. So that's what that is. That was, the decision was made in the House, make this the omnibus Sunday hunting bill.
Okay.
So that's what that is.
Okay.
That language down there, that 16 through 18.
Right.
That is just reiterating what we already said about the deer damage permits, which is that
Correct.
they cannot be used in those specified counties to authorize Sunday hunting.
Right. But my question was, and after that, I will, for when the amendment was Baltimore County, Howard County, and Prince George's County, are there delegation letters? And if there are, then I'll seek a delegation letter.
Well, so that was introduced by the Senator Hester amendment, and that was meant to mirror existing language in the code on page 76. So if we're looking on the next page, this current, there is a currently, those are the counties where currently there is
Which
essentially
includes
no
Baltimore City.
Sunday hunting.
Which includes Baltimore City.
Correct, and that's why Baltimore City is included in that provision that deals with the deer management program.
Right, and which is why my amendment to add Baltimore City to the Baltimore County, Howard County, Prince George's County.
That's not what your bill does, no, that's not what your amendment does. That, Baltimore City is already in that group, because that group is the sort of prohibited Sunday hunting group. Your amendment touches this piece that was added, again, by the House, pulling in that Baltimore City standalone bill that just would have opened up Sunday hunting for
So-
each Sunday during the bow hunting
Was there a
season.
letter from the delegation to allow that to happen?
There was a letter from the delegation on the original bill.
Was there a letter from the Senate delegation to add that provision, or the House delegation to add that provision to the omnibus bill? I mean,
I
if,
don't know what the process was in the
Right.
House, but again, typically if the delegation approves of a provision of law, moving it to another bill doesn't really matter, because it's the delegation supported, right, the bill to authorize Sunday hunting during the bow hunting
Well,
season.
again, if we're, and again, now I will stop that if we are requiring letters from, to approve certain amendments, I would say, as chair, I don't recall us taking a position, on adding it to the omnibus bill. So, but I'll leave that, and maybe we'll have a floor amendment to address it.
So for purposes of now, just to clarify, we're not pushing the amendment now, perhaps on the floor, and maybe, okay. So now all we have in front of us is we've got that 3 Hester amendments, which we adopted a few days ago. Just on that, now we have an underlying bill with 3 amendments. Questions, maybe to Senator Croz's point, questions about the bill. We have 3 amendments, we have a bill, no Bailey amendment, and that's where we're at. And in this posture, for the most part, exception of the Hester amendments, the bill did pass 131 to 6 in the House. I think fundamentally the same bill. But, okay, Senator Croza, questions for April on the bill broadly?
Thank you. So with all that said, could you very succinctly, April, just walk through the base bill and the Hester amendments that were added, so we all, and to clarify the question I've asked about what individual counties can do?
Right. So with the Hester amendments that were adopted by the committee, the bill, it still basically does a couple things. First, it says, it creates this new deer damage permit. With the Hester amendments, it cannot be used in those, well, I'm just going to call them the prohibited counties: Baltimore City, Baltimore County, Howard County, Prince George's County. Cannot be used in the prohibited counties to authorize Sunday hunting, but everywhere else across the state, this would be a new permit that would authorize owners of larger tracts of land that have documented deer damage on them to obtain this permit and potentially do Sunday hunting to reduce deer population under that permit. Additionally, the bill would authorize for a 3-year period beginning July 1st, 2027 and ending June 30th, 2030, it would repeal across the board our existing county-specific Sunday hunting authorizations and require DNR to adopt regulations pertaining to Sunday hunting that at a minimum allow for Sunday hunting in the manner authorized under statute. Right. Again, as amended, the bill is very clear. It does not allow them to open it up at all in those prohibited counties, but any other county could go to the department and they would have to have some sort of letter from the county government requesting a change, and they could have changes to authorize additional Sunday hunting in their county. And then those regulations, they're set, the section of code authorizing those regulations expires June 30th, 2030. So if the General Assembly did not act, it would, at that time, it would come back to the current restrictions. But But in terms of asking about flexibility, outside of those prohibited counties, this would give counties the flexibility to work with the department to authorize additional Sunday hunting.
So if you're looking at the revised fiscal note under Sunday hunting, and it talks about Kent and Talbot, and then it also talks about Wycomico County, because they went ahead and got they wanted some revisions specifically, but they were already on record making that request through an earlier bill. If, let's say, Somerset County saw that Wycomico County had this, Somerset County could come at a later date after the bill is enacted and work with DNR to perhaps have a similar hours or setup. Is that correct?
Yes.
Okay, thank you.
Okay, additional questions for April? Okay, Senator Harris. Okay, Senator Washington.
A question or an intent that this will go to the floor, and this provision about allowing a person to hunt deer on each Sunday in Baltimore City that's been added, again, I would say that that was not something that was discussed in our delegation. So just to give you, probably my amendment will be something to that, and then I will confer that with, so it may be, once we pass it, I will likely ask for the bill to be held over or to lay over so that we can get it clarified within our delegation. So that's my plan.
Okay, fair enough. Senator Harris moved the bill along as amended with the Hester amendments, second from Senator Carrozza. Okay, let's do a roll call on this one, Lamorio. Again, we've got House Bill 1063
All right,
as amended.
Senator Kagan? Aye. Senator Kagan, yes. Senator Hester? Yes. Senator Hester, yes. Senator Watson? Senator Watson, yes. Senator Attar? Senator Attar, yes. Senator Harris? Senator Harris, yes. Senator Brooks? Yes. Senator Brooks, yes. Senator Carrozza? Yes. Senator Carrozza, yes. Senator Washington? Yes. Senator Washington, yes. Senator Salmonet? Senator Salmonet, yes. Senator Feldman?
Oh, yes, that bill carries. Let's move to the Bailey bill, which is Senate Bill 643. Would everybody like to be, we will conform?
Yeah. amendment.
Everybody okay with conforming what we just did to the Bailey bill, and everybody's vote will count the same? Is everybody good with that? Okay, all in favor of us doing that, raise your hand. All opposed? So the Bailey bill, Senate Bill 643 passes as well. Okay, next, we have some bills that have to still go to other committees, the B&T in particular, but there's a few priority bills. I just want to, let's go on page 2, House Bill 525, Stacy, from Delegate Boafo.
Okay. House Bill 525, County Boards of Education, Student Electronic Communication Device Use Policy Establishment, Maryland Phone-Free Schools Act. This bill requires each local board of education to develop and implement by the 27-28 school year a policy to prohibit the use of electronic communication devices by students during the academic school day. Local policies must prohibit the use of devices, require students to store devices as specified, and prohibit a student from using or accessing a social media platform. Local policies must also require the administrator approval for the use of personal devices for educational purposes when a school-issued device is unavailable, and include appropriate disciplinary measures as specified. Policies may not prohibit a student from using devices in certain specified situations, and each local board of education must engage families and publicize the policies. The Maryland State Department of Education must adopt regulations to implement the bill. And lastly, the bill specifies reporting requirements for local boards and MSD related to policy development and implementation. There are amendments offered by Senator Harris on page 41 with a reprint on page 43. These amendments alter the short title of the bill to be the Joanne C. Benson Maryland Phone-Free Schools Act. It clarifies that the bill does not apply to the Maryland School for the Blind or the Maryland School for the Deaf, and it alters the policy exemption provisions related to students with disabilities to expand allowable uses for students with disabilities.
Okay, Senator Harris, you want to add anything to what Stacy said about the Harris amendments?
No, just the point that obviously we are naming it after Senator Joanne C. Benson. They made the the award a few weeks ago and talked about how 20 years ago, she foresaw that this was going to be an issue in our schools, so I thought it would be fitting to name it after the good senator from Prince George's County, so move the amendments.
Okay, Senator Harris moves the amendment, second from the vice chair. Okay, all in favor of the Harris amendment, raise your hand. All opposed, that motion carries. We have House Bill 525 as amended, moved by Senator Harris. Is there a second? Okay, the vice chair is second. Okay, further discussion on HB 525 as amended. Okay, all in favor of 525 as amended, raise your hand. All opposed, motion carries. Let's go over to page 3, bill that has to go over to B&T still, House Bill 849. Stacy? 849 on page 3.
House Bill 849, Child Care Scholarship Program, Freeze and Enrollment, Exceptions, and Waitlist. This bill prohibits a freeze in enrollment in the Child Care Scholarship Program from applying to a family or an individual who is enrolled in the Temporary Cash Assistance Program, a family or an individual who is enrolled in the Federal Temporary Assistance for Needy Families Program, a child, parent, or caregiver who is enrolled in the Federal Supplemental Security Income Program, a sibling of an enrolled child, or a child who is homeless. These individuals must otherwise meet criteria for enrollment in the program. The Maryland State Department of Education must establish a wait list during any enrollment freeze, which must give priority to certain applicants. The bill also requires MSDE to develop a new application for the program that collects specified information and review the methodology used to determine whether a parent or guardian is attending a job training program for determining eligibility for a scholarship. The bill is contingent on the passage of House Bill 1321 that, among other changes, modifies the program application process and co-payment levels. There are no amendments.
Okay. Questions for Stacy on House Bill 849? Okay, Senator Harris moves the bill. It's clean. There are no amendments. Second from Senator Carrozza. Discussion? Okay. All in favor, House Bill 849, raise your hand. All opposed, motion. Yeah, okay, and one abstention from Senator Simon Ayer. Okay, actually, so on the same page up at the top, House Bill 640 is being held at the request of one of our members. Further down, another, again, bill that has to go to still to B&T, House Bill 972, Delegate Miller. April, why don't we just take that up? Again, this bill named after former Delegate Charles J. Otto. Okay, so April, on House Bill 972, again, this has to go over to B&T still.
Okay. House Bill 972, Maryland Fair and Agricultural Education Promise Fund Establishment, the Charles J. Otto Agricultural Education Promise Act. This bill establishes the Maryland Fair and Agricultural Education Promise Fund to advance agricultural fairs and education in the state. The bill requires the governor to include $200,000 for the new special fund in the annual budget bill each fiscal year. The bill also repeals the requirement that a specified amount from the State Horse Racing Special Fund be provided to the Maryland Agricultural Education Foundation to promote statewide agricultural education. There are no amendments. Move the bill.
Okay, no amendments. We have Senator Carrozza moving the bill. Again, we're on House Bill 1063, a second from Senator Harris. Discussion. Okay, all in favor, House Bill 1063, clean, raise your hand. Oh, I'm sorry, no, wrong one. House Bill 972, raise your hand. All opposed? House Bill 972, clean, passes. Okay, let's go, again, keeping with the theme of B&T bills. On page 4, let's go to House Bill 1321. Stacy?
House Bill 13, oh, sorry. That's all right. House Bill 1321, Child Care Scholarship Program, Application Process, and Co-Pays Alterations. This bill authorizes the Maryland State Department of Education to award partial scholarships and to set a sliding fee co-payment scale for the Child Care Scholarship Program. The bill also prohibits charging co-payments for certain households. While an enrollment freeze is active, MSDE must identify, inform, and assist program applicants who qualify for enrollment in publicly funded pre-kindergarten, Head Start, and Early Head Start. In addition, the bill repeals current statutory provisions related to presumptive eligibility for the program applicants. The bill also establishes notification requirements for families and providers should MSDE implement the sliding fee scale and requires MSDE to report to the General Assembly as specified. The bill is contingent on the last bill we just discussed, and that makes changes to the wait list. There are no amendments.
Okay, no amendments. Any discussion, questions for Stacy? Again, we're on House Bill 1321. Okay, is there a motion? Okay, Senator Brooks moves the bill, second from Senator Harris. And again, further discussion. Okay, House Bill 1321 is in front of us. All in favor of the favorable motion, clean, raise your hand. Anybody opposed? Okay, Senator Simon Ayer will abstain on that bill. The bill carries. House Bill 13. Okay, now let's go back to the page 1. Let's start at the top of the list and work our way through and see where we land. Okay, we'll start with House Bill 14. Stacy.
House Bill 14, County Boards of Education, Bullying, Harassment, or Intimidation, Information Collection and Reporting Requirements. This bill requires, under specified conditions, local school systems to include in their annual report to the State Board of Education on bullying, harassment, and intimidation incidents that, after a thorough and impartial investigation, are determined to have been motivated in whole or in substantial part by personal characteristics of the individual being bullied, harassed, or intimidated. It also requires each local school system to post annually in a prominent location on its website information about such incidents. A local school board may not publish any information that could be used to identify an individual student. 3 amendments have been offered on this bill. The first offered is from Senator Brooks. You'll find that on page 6 and the reprint on page 7. And this amendment strikes the subjective circumstances under which a county board would have to report incidents of bullying, harassment, or intimidation motivated by specified personal characteristics, which has the effect of just requiring the reporting the information without any conditions at all. I believe this amendment was the one supported by the sponsor during the hearing.
Okay, Senator Brooks, you want to add anything?
The bill just takes meaningful steps to address hate bias in Maryland schools before it escalates to a criminal conduct. And I had a conversation with its sponsor of the bill, and she's in agreement with this amendment.
Okay, Senator Washington.
Okay, so, yeah, I have an amendment with the bill as well. Okay.
We'll take them up one at a time. We have a Brooks amendment. Okay, before we take up the Brooks amendment, let's go to the vice chair for questions.
Thank you. Stacy, I'm reading the bill before the amendment. So I'm on page 4, lines 23 through 28. The definition of group, is that like my clique, my gang, or is it, white women who, the word right around group, in that particular group? There is a disproportionate incident rate of bullying, harassment, or intimidations for student in that group.
Well, that's language being stricken.
Aware, I want to understand it.
If you look on page 10 of the reprint there that's being shown, by the amendment offered by Senator Brooks strikes that language.
Yes, I'm in the, so there's no other reference to group in that group that would stay?
Right. So
Okay.
what it was initially getting at is, for
Yes.
example, if a student was harassed because they were Jewish, if a student harassed because they were Black, then it would say that group, meaning
Yes.
identifying with that personal characteristic.
Thank you. Thank you, Mr. Chair.
Okay, any additional questions? Okay, we have the Brooks amendment. Did you want to move your amendment? Okay, Senator Brooks moves the Brooks amendment. Is there a second? Second from Senator Harris. Okay, any further discussion on the Brooks amendment? All in favor of the Brooks amendment, raise your hand. Anybody opposed to the Brooks amendment? Okay, Senator Washington abstains. That motion carries. We're going to go back to you, Stacy, for additional amendments.
So if you look on pages 11A and 11B of your reprint of your packet, this is the first amendment that's offered by Senator Washington. So her amendment also makes changes essentially to that same section. So this would say, a county board shall include in its report incidents of bullying, harassment, or intimidation of students disaggregated by personal characteristics described in subsection A2I1. And then her amendment keeps those provisions that were struck in the Brooks amendments, but says, beginning October 1, 2027, an analysis of any increase or decrease in incidents of bullying, harassment, or intimidation for students, and a calculation of any disproportionate incident rate of bullying, harassment. So these are kind of conflicting amendments.
Okay, so
So I guess the
Washington, I
committee
mean,
would have to decide how they wish to.
So these amendments are, well, the way we received the bill, the amendment about the county board, these these amendments were put there by the committee. And I thought rather than completely striking what the committee was what the House committee wanted, was to sort of clarify it. And so what this amendment does is, I think the idea of disaggregating the information into different groups, like the goal is that they don't want just a single number, but to disaggregate it. So I clarified that language. And I referenced the language, rather than saying groups, et cetera, I referenced the language that's actually in that statute, which lists out the different characteristics. So we want the disaggregation to be by the characteristics that are in that section, and that is section A21. And then there was this, this interest in the, it seems like they were interested in this disproportionality. In other words, are there changes in different groups? So I redrafted it to really clarify what I think was that intent of the House committee. And so it says, it gives you a year of collecting this disaggregated data, and then it requires that we add a calculation to look at the changes in different groups. So that's what this bill does. So it maintains what the House's intent was, that there would be some disaggregation. It eliminates, however, their requirement, which is what I spoke with the bill sponsor yesterday, and it was my understanding that we were good with some of this, that it seems like some of what the House wanted to do is say, well, we're only going to report it if it's been determined that there be an investigation. I stripped that language. And so this way, you know, we're not evaluating it. It's not any kind of investigation. We're just getting the data. And I think that that would be really helpful for understanding it.
okay. Before we discuss this amendment, is there another amendment beyond this one? Yes. Okay, the reason I ask is because now we have an amendment that at least appears, based on what Stacy said, to be in some conflict with the Brooks amendment we just adopted. And so can we just describe the third amendment? Because what we may need to do is maybe we hold it a day, because we have a conflict. Maybe that could be resolved, but I don't want to have a big debate here between conflicting amendments. What's the next amendment, just so we put it on the table so we know what we're dealing with?
If you turn to pages 11C and 11D in your packet, so this amendment strikes the current law came in as if the incident is believed to have been motivated in whole or substantial part by any of an actual perceived personal characteristics of this section, then indicate those personal characteristics if known. So Senator Washington amendments would require this, each victim form shall identify any actual perceived personal characteristics described in this subsection that are believed to have been a motivating factor in the incident.
That does is that there's a form. So again, this is just this is administrative data collection. So in order for there to be a disaggregation, at the time of taking the report, there needs to be the option to select any of the characteristics that are already defined in law. So that's what this does. And so it's not adding this that are believed to have been motivating. This is not new language. This is language that is already in the article. And it's just directing that the form actually has that as, you know, when you collect it, was it motivated by gender, religion, et cetera? So we have that. So that's what this amendment does.
Okay, so here's what I'm going to propose because of this, the two amendments being, why don't we hold this bill and Senator Washington Brooks, maybe in consultation with Stacy, can figure out maybe how to resolve this before we take this up again tomorrow, because we'll be voting again tomorrow. I don't want to get back into this back and forth. Senator Brooks?
Yeah, I had just got some communique from the sponsor, and she was saying that this, you know, we've got the AG was in agreement with this, and plus that, Senator Washington, did you share on that amendment with the sponsor in the House?
I met with the sponsor for an hour yesterday, going through and explaining that, you know, going through the amendments, spoke with her, I met with her and her chief of staff. It was my understanding that, you know, that this is a data collection provision, and that the way that the amendments from the House was drafted was confusing. And so, not confusing, but that there was language that could get at their intent, and also get to the sponsor's intent, which was to really disaggregate, because right now, things are just being reported all lumped together. There was this number of bullying, harassment charges.
Okay.
So I did speak to the sponsor.
Let's hold this bill and sort it out is what
All right.
I think we need to sort it out. Conversations with the sponsor in the House, two amendments that cannot coexist. Vice Chair, last word, and then,
Last word.
yeah.
Thank you, Mr. Chair. I think sorting it out is a good idea. I voted for the Brooks amendment, but I raised questions about the word group. And I think group isn't defined. It doesn't say demographic or all that. It could be a group of lacrosse players who always wear the same uniform and they're bullied or harassed or something. I'm thinking the movie Mean Girls. I think it's not defined. I actually think this Washington amendment, the first one, is a little more precise. I kind of like that. So I'll be curious to see what the advocates and colleagues and council come up
Okay.
with. Thank
Okay,
you.
let's move on. Here, we have a couple of bills. I just want to, I'm going to jump around here. Go to page 2. We have a bill from the Speaker, House Bill 554. Devin, why don't we take up the Speaker's bill, House Bill 554?
I love when you jump around. House Bill 554, General Assembly, Legislative Committees, Renaming and Legislative Policy Committee Membership. This bill alters terminology throughout the Maryland Annotated Code to reflect the renaming of the House Health and Government Operations Committee to be the House Health Committee, and the renaming of the Senate Education, Health, and Environmental Affairs Committee to be the Senate Committee on Education, Energy, and the Environment. The bill also adds the chair of the new House Government and Labor Elections Committee to the Legislative Policy Committee, alters the membership of the Legislative Policy Committee to include 3 additional members of the House of Delegates rather than 4, and makes other conforming changes. The bill takes effect June 1, 2026. There are no amendments.
Okay, no amendments on the Speaker's bill, House Bill 554. Okay, favorable from Senator Watson, second from the Vice Chair. All in favor of House Bill 554 clean, raise your hand. All opposed, motion carries. Let's go to a couple of local delegation bills. On that same page, House Bill 597, Devin, from
House
Montgomery
Bill-
County.
House Bill 597, Montgomery County Community Choice Aggregation Pilot Program Alterations, MC 17-26. This bill alters the Community Choice Aggregation Pilot Program in Montgomery County. Specifically, the bill alters provisions governing the pilot program's beginning date such that it must begin on the earlier of the date the county gives specified notice to the Public Service Commission, or April 1, 2026. Instead of April 1, 24. Extends the duration of the pilot program from 7 years to 9 years, requires the Public Service Commission to submit its interim report on the status and the effectiveness of the pilot program to the General Assembly in the 7th year of the program rather than the 6th, and extends the deadline for the Public Service Commission's final report to the Governor and General Assembly from December 31, 2031 to December 31, 2035. There are no amendments.
It's a local Montgomery County delegation bill, no amendments. Any discussion? Okay, Vice Chair moves favorable, second from Senator Harris. Discussion on the local bill. House Bill 597 clean, all in favor, raise your hand. Opposed, that motion carries. Okay, sticking with the local bills, go to page 4. We've got a Prince George's Montgomery delegation joint bill, House Bill 1185. Top of page 4, April.
House Bill 1185, Washington Suburban Sanitary Commission Personnel Management Appeals of Disciplinary Suspensions. This local bill authorizes a Washington Suburban Sanitary Commission employee to appeal a suspension for disciplinary actions to the Office of Administrative Hearings. The office must dispose of a case or conduct a hearing and issue a final decision in an appeal for the suspension of a WSSC employee. The bill has the support of the Montgomery County and Prince George's County Senate delegations. There are no amendments.
Okay, we have a bi-county bill here, support from both delegations. House Bill 1185, no amendments. Senator Harris moves the bill, second from the Vice Chair. All in favor, House Bill 1185. Raise your hand. All opposed, motion carries. Okay, let's keep with that. House Bill 1230, another bi-county Prince George's Montgomery County bill. Again, House Bill 1230. April?
House Bill 1230, Washington Suburban Sanitary Commission Procurement Alterations. This local bill expands an existing local small business preference program in the Washington Suburban Sanitary Commission to include additional categories of eligible businesses. Finally, the bill repeals the name of the WSSC's Office of Supplier Diversity and Inclusion and requires WSSC to adopt regulations establishing a name for the office. There are amendments to this bill. They are on page 96, 95. Reprint starts on page 96 of the voting packet. The amendments that were drafted from or offered by the Prince George's County Senators specify that the program's purpose includes giving preferences to local small businesses and local businesses. This bill and the amendments are supported by both the Prince George's County and Montgomery County Senate delegations.
Okay, so we have the amendment, Prince George's, supported by Montgomery County. Okay, Senator Harris moves that amendment. Is there a second from Senator Watson from Prince George's County? Looks like he's a second. Okay, all in favor of the Montgomery Prince George's amendment, raise your hand. Opposed? Okay, we now have House Bill 1230 as amended. Senator Harris, second from Senator Watson. All in favor of House Bill 1230, raise your hand, as amended. All opposed? Okay, that motion carries. House Bill 1252, another local delegation bill from Montgomery County. April?
House Bill 1252, Department of Housing and Community Development, Montgomery County Study. This local bill requires the Department of Housing and Community Development to study and make recommendations regarding housing availability and affordability in Montgomery County. The department must submit a preliminary report of its findings and recommendations to the General Assembly, Maryland National Capital Park and Planning Commission, Montgomery County Planning Department, Montgomery County Executive, and Montgomery County Delegation by February 1st, 2027, and again the following year. The bill is supported by the Montgomery County Senate delegation.
Okay, local Montgomery delegation bill, no amendments? Okay, is there a motion from the Vice Chair for Montgomery? Is there a second? So Senator Harris. Okay, we have in front of us the local delegation bill for Montgomery, House Bill 1252. All in favor, raise your hand. All opposed? Motion carries. Okay, we got two bills on page 3 from couple of House chairs I'd like to put on the table. Start with House Bill 643 from Delegate Chair Valderrama. Devin?
House Bill 643, Certified Public Accountants Licensure Qualifications. This bill is the cross-file to Senate Bill 34, which was heard in the committee earlier this session. It establishes alternative pathways to licensure as a certified public accountant by the State Board of Public Accountancy. Under the bill, practical work experience requirements may be completed over a longer period, while educational and experiential requirements may be combined in alternative ways to qualify for a license. There are no amendments.
Okay. I apologize. There were no amendments? It was
Correct.
clean, correct. Okay, I think this is a high priority for our Maryland CPAs. And so with that, Senator Harris moves the bill. We're on House Bill 643. Is there a second? Okay. Second is there from Senator Carrozza. All in favor of House Bill 643, clean, raise your hand. Opposed? That motion carries. Let's go down to Chair Corman's bill, House Bill 870. Devin? I'm sorry, April. My apologies.
Probably should have been. House Bill 870. Environment Permit Applications for New Buildings Notices, Large Buildings for Tomorrow Act. This bill requires, beginning July 1st, 2026, within 10 business days after a local government accepts a permit application for a new building that has a proposed gross floor area of 35,000 square feet or more, excluding the parking garage area, the local government to provide notice of the permit application to the Maryland Department of the Environment. The bill applies only prospectively to new construction for which a complete commercial or residential service request is made to the local utility, or a development application or building permit application is filed with the local government after the bill's effective date.
Okay, on Chair Corman's bill? Okay. Is there any information that you'd like, just so we know?
It's been significantly amended, and so we'd just like an opportunity to digest that and to possibly amend it.
Okay. Okay, let's move on then. Let's go back to page 1 again. House Bill 146, Delegate Guyton bill.
House Bill 146, Environment On-Site Wastewater Systems, Requirements for Inspections and Pumping Services and Implementation Dates. This bill will look familiar. This is the bill that was recommitted, or the Senate version of the bill was recommitted. The bill requires a landlord of property that is served by an on-site wastewater system or septic system to ensure the septic system has been inspected and pumped out before each new tenant occupies the property. It also establishes inspection and pump out requirements for the sale of property. The bill also requires the Department of the Environment to adopt regulations related to the State Board of Wastewater Professionals by July 1st, 2027, instead of by July 1st, 2025, and delays from July 1st, 2026 to July 1st, 2028, the date by which an individual who provides on-site wastewater services must be licensed by the board. There are amendments in the voting packet on page 12, reprint starting on page 13, being offered by Senator Feldman. The amendments strike provisions of the bill relating to inspections and pump outs. As amended, the bill simply extends the timeline for MDE to adopt regulations related to the State Board of Wastewater Professionals and the deadline for wastewater professionals to obtain licenses from the board.
Okay, questions for April on that amendment? Okay, Senator Carrozza.
I'm just trying to play catch up. We had this bill and now the House bill's crossed over and your amendment, could we just summarize that amendment?
It kind of narrows it.
Okay.
Right, because so the bill as it came in sort of did two things. It established all these requirements related to inspections and pump outs for rental properties and for property sales. That's sort of one portion of the bill. The other portion of the bill was simply delaying. There was a requirement under a bill that was passed a couple of years ago that set up this board to license waste septic professionals and required the department to adopt regulations. That process has been quite delayed. They were required to have regulations in place by last summer. They're not ready yet. Under the original bill, septic professionals are actually required to be licensed by this board by this summer, and that structure just has not been set up yet. So Senator Feldman's amendments would cut all the pieces having to do with inspections, property transfers, pump outs, and just delay those effective dates, giving this board more time to be set up before septic professionals need to be licensed.
Okay, move the amendment.
Okay, and, you know, there was a lot of back and forth on a bunch of stuff on the floor, to be honest with you, that got away from, and so I think this sort of makes it a little simpler on multiple fronts, just acknowledging that whole thing. Okay, so we had just on this amendment, motion from Senator Carrozza, second from, yeah, from Senator Brooks. Okay, all in favor of that amendment, raise your hand. All opposed, that amendment carries. We've got House Bill 146 as amended in front of us. Senator Brooks, would you want to move the bill as amended? Is there a second? From Senator Harris, all in favor of HB 146 as amended, raise your hand. All opposed, okay, motion carries. Let's go down to House Bill 149.
While we're on that one.
Sure.
Senator Brooks, do you want to move, the Senate bill is on the list.
Oh,
too.
right, we've
Would you
got
like to
the
move your bill as
cross-file.
well? Okay.
Yeah, okay, so everybody good with conforming?
Senate Bill 165.
Senate Bill 165 is Brooks' bill, we're going to conform it, and everybody's vote will count the same. Everybody all in favor of doing that, raise your hand. That motion. Okay, so the Brooks bill will get sent back to the floor. House Bill 149 from Delegate Charkoudian, I think it's a cross-file of Chair Smith bill.
Yes, yes. So House Bill 149, fire prevention, assistant fire marshals, residential rental high-rise property, fire safety equipment, and fire alarm system technicians. The Senate Bill 513 is a cross-file, which you heard earlier this session, and is on the list. This bill, as amended, requires the installation of automatic fire sprinklers in other specified equipment beginning October 1, 2026 in each residential high-rise building that is undergoing a substantial renovation. The State Fire Prevention Commission needs to adopt regulations to establish a program to license and regulate fire alarm system technicians and fire alarm system companies in the state. The state fire marshal would approve the appointment of an assistant state fire marshal by a county or municipal government, or at the request of a local government, designate an individual to serve as an assistant state fire marshal. And finally, the Office of State Fire Marshal would adopt regulations to establish requirements and standards for all individuals designated as assistant state fire marshals or special assistant state fire marshals. There are amendments in your packet on page 19 offered by Delegate Charkoudian. The amendments clarify that local laws on substantial renovations applies to this bill, and it addresses the concerns raised by from the Apartment and Office Building Association.
Chair Smith, he's
Chair,
seen those amendments?
yes,
He's good with
so
these?
Senate Bill 513 will have the exact same amendments
Okay.
to it.
Okay, we've got these amendments from Delegate Charkoudian, which is sponsored Chair Smith, supportive of. Any motion on the amendments? Move the amendments. Okay, Senator Harris moves the amendments. Senator Brooks seconds. Discussion? Okay, all in favor of the amendments, raise your hand. All opposed, amendments carry. We have House Bill 149 is amended. Senator Harris moves the bill. Senator Brooks second. All in favor, HB 149 as amended, raise your hand. Opposed, motion carries. So similarly, let's transition to Senate Bill 513. Devin, we can conform.
So that with the amendments attached in the packet, that bill would conform to what you just did to House Bill 149.
Okay. So, and everybody good? And then same vote on HB 513 as we just did for the cross-file on House Bill 146. All in favor, again, of Senate Bill from Chair Smith, 165, raise your hand. All opposed, bill carries unanimously. Let's go down to HB 220.
water individual submeters. House Bill 220 is identical to Senate Bill 130 as it passed this committee 9-2. The bill authorizes the installation of individual water submeters located in certain apartment houses and mobile home parks, subject to specified accuracy, record-keeping, billing, and complaint resolution requirements.
Okay,
There are no amendments.
No amendments, and this is the same bill that passed 9-2, Senate Bill 130. Okay. Is there a motion on House Bill 220? Senator Harris moves the bill, Senator Brooks second. All in favor? Well, what was the, just remind us, Laura, who were the, just so we recall, who were the two, just so everybody remembers.
Call them out.
There was a galleon.
Yeah, Galleon, Cruz, or against.
That's good.
I'm looking at the vote.
Okay, okay, Senator Simonero advises that Gallion and Carosa were the two dissenting votes.
Council confirms.
Okay, so with all that said, we have House Bill 220 as amended before us. All in favor of House Bill 220, raise your hand. All opposed? Senator Carosa is in the red. That bill carries. House Bill 247, April.
House Bill 247, Chesapeake and Atlantic Coastal Bays Critical Area Protection Program, variances, alterations. This departmental bill alters certain standards and requirements for variances from land use requirements under the Chesapeake and Atlantic Coastal Bays Critical Area Protection Program. I should just add that the Critical Area Commission indicates these changes largely codify standards and requirements that are current practice, including those established through case law. There are no amendments.
Okay, we've got no amendments on House Bill 254. A question from Senator Carosa?
Did we have a similar?
I'm sorry,
Did we
247.
have a similar bill on this? Because I think we had something with the critical areas. And
Yeah, that's later on this list. That's
so
258.
what does this bill do?
So this has to do with variance procedures, and I believe somebody from the Critical Area Commission is here if we need additional assistance. But this is when people are applying for variances within the critical area, clarifying sort of the rules and the standards that apply.
We do have somebody here. First of all, give us your name.
Yes, good afternoon, Nick Kelly. I'm Executive Director with the
Okay.
Critical Area Commission.
Okay, so any questions for Mr. Kelly, just about the bill? Senator Carosa?
I'm just trying to kind of, could you bottom line the bill and also how this would impact working with local counties or local property owners?
Yes, so the process for getting a variance will be exactly the same. What this is doing is providing consistency by taking existing court cases and incorporating it into the statute and into the provisions. So the process will be the same, and in coordinating with the counties will be exactly the same.
So can you summarize that process?
The process, so for an applicant, if they had a variance, they wanted to put, let's say, a deck in the buffer, they would go to the local county, submit an application. That application would go before the local Board of Appeals. The county would provide input on whether they believe it meets the variance standards or not. Commission provides a comment letter. All that process is the same. They have to meet a certain number of statutory standards. These are being amended to incorporate existing court cases that have made some decisions on what reasonable, significant other pieces are. So it's providing a little more justification to those standards.
So if they were basing it on the court cases, there may be some higher standards in those court cases that are now applied to these standards?
I think it's providing more consistency to the standards in the way the court cases are being applied, that with different boards of appeals, the interpretation of those wording has been different. So by taking in these court cases, it's making it more clear exactly what those standards mean.
Okay, Senator Simonero?
So legal counsel, I saw it came in with some opposition, Mako and NIAP, and maybe some others. And I saw that they adopted some amendments in the House, and I'm looking at our committee testimony in EEE. I don't see any unfavorable So is that to make those okay with the amendments as drafted?
My understanding is that the amendments added in the House removed opposition to the bill.
Okay. It's still, it was 96 to 37, but it's interesting. Okay, thanks.
Okay, additional, yes, Senator Cardoza?
Before the House vote, or they've been, no one's amended this? Is this?
Right, this is the bill as it came over from the House.
This is the House bill.
It's a House bill.
But there's no amendments on this House, no one's put any amendments on this.
Not additional to what was already added in the House.
Right, we just have the House bill clean right now, which apparently removed the opposition. Okay, everybody have enough information? Okay, with that, okay, Senator Washington moves favorable on House Bill 247. Senator Harris seconds. All in favor of House Bill 247, clean, raise your hand. All opposed? Motion carries. Okay, one abstention from Senator Cardoza. Okay, House Bill 254, April.
House Bill 254, Supporting Inclusive Community Adaptation Act. This departmental bill from the Department of Natural Resources requires the department to facilitate community participation in the planning and development of department projects. The bill also establishes a grant fund administered by DNR and certain other DNR efforts focused on climate change resiliency. Finally, the bill makes modifications to provisions governing an existing loan fund for shore erosion control projects, including the removal of certain funding limitations and the authorization of partial loan forgiveness. There are no amendments.
Okay, questions for April on House Bill 254? Okay, any motions? Okay, Senator Brooks moves the bill. Second from Senator Washington. All in favor of House Bill 254, clean, raise your hand. All opposed, motion carried. An abstention from Senator Cardoza. Okay, House Bill 258, April.
House Bill 258, Chesapeake and Atlantic Coastal Bays Critical Area Protection Program Standards and Procedures. This is another departmental bill from the Critical Area Commission. This one we did hear in the Senate, but ultimately did not move it. The bill makes clarifying and corrective changes to provisions governing the Chesapeake and Atlantic Coastal Bays Critical Area Protection Program. Specifically, the bill clarifies the Critical Area Commission's adoption and amendment of regulations must be accomplished by affirmative vote of the Commission, corrects a reference to a 6-year comprehensive review of a local critical area program to instead refer to a 10-year comprehensive review consistent with changes made under Chapter 424 of 2024. Defines the term adjacent for purposes of provisions governing the location of new intensely developed or limited development areas, clarifies that a change to a critical area designation due to a mistake in the original designation must be based on land use or natural features in existence on June 1st, 2002, when the critical area program was expanded to the Atlantic coastal bays. Extends from 90 days to 130 days the timeline for the commission to act on a program amendment in cases where the commission has overridden a determination by the chair. And I would just note that this timeline is consistent with the existing 130-day timeline for consideration of program amendments in other circumstances. Clarifies references to professionals who may prepare, oversee, and approve plans to replant trees or remedy illegal cutting or clearing. And finally, requires that damages assessed by a circuit court for illegal cutting or clearing of trees in the critical area are to be paid to the applicable local jurisdiction rather than to the Department of Natural Resources. There are no amendments, but there is a key difference between the bill as it came over from the House versus the bill that was heard in this committee. As you might recall, the original bill got rid of the adjacency standard and said that said that the development areas would have to be, or the areas would have to be contiguous and adjacent. There was an amendment worked out that I believe was agreed to by the people who are the stakeholders that opposed that change initially, that just defines adjacent in a way that is sort of consistent with how all the parties believe it should be defined.
Okay, Senator Cardoza.
Did that remove Mako's opposition?
Yes.
the amendment that came on the House bill, but that was not on the Senate bill?
Right, so and again, the Senate bill, just, we never moved because things were being worked out in the House. But yes, MACO does not oppose the version that came over from the House.
And I think there was other opposition testimony. Did that take care of that as well?
So that was a kind of linchpin of a lot of the opposition, was that adjacency standard. There was some concern initially also about that extension of the timeline for the commission to act on program amendments in cases where the commission has overridden a determination by the chair. I believe that opposition was just taken care of by further discussions with the stakeholders, that extension is really just to bring that provision in line with the current 130-day timeline for consideration of program amendments in all other circumstances. So my understanding was that opposition was never even raised in the House. They had their hearing after the Senate.
Okay, additional questions for April? Okay, bottom line, we don't have any new amendments on the House bill, so this is a vote clean. It appears that most of the opposition, if not all, has been taken care of. Senator Harris moved the bill. We're talking Senator Harris, House Bill 258 moves the bill. Senator Brooks, second. Senator Brooks, you second? Okay. All in favor, House Bill 258, raise your hand. All opposed? Okay, let's go to next page. Okay, House Bill 260, Stacy.
House Bill 260, Public Financing Act, Fair Campaign Financing Fund, distributions. This departmental bill alters the earliest date on which distributions from the Fair Campaign Financing Fund may be made to candidates for governor and lieutenant governor participating in the gubernatorial public campaign financing program under the Public Financing Act. The bill moves the date from January 1 of the year of the election to July 1 of the year before the election. There is one amendment offered by the chair on page 27 of your packet, and this amendment conforms the bill to Senate Bill 11 as passed by the Senate, requiring a continuing political committee to file a campaign finance report on the fourth Wednesday in January instead of the third Wednesday to align with the federal filing deadline, and requires that this report cover a certain period of time and makes a technical correction.
So this can, okay, we have, the vice chair moves the amendment, second from Senator Harris. Okay, all in favor of the amendment, raise your hand. All opposed? Okay, that motion carries. Senate Bill 260 as amended is in front of us. Vice chair moves the bill, Senator Harris is second. Again, House Bill 260 as amended, raise your hand. Okay, all opposed? Vice Chair, Senator Carrozza is negative. Senator Simonero? No. Okay, you're good. Okay, that motion carries. Let's go to House Bill 270. Devin, Military Family Inclusion Act.
House Bill 270, Military Family Inclusion Act. Excuse me. This departmental bill is the cross-file to Senate Bill 192, which passed the committee unanimously. It alters the membership of the Maryland Commission on Caregiving, the Board of Trustees of the Maryland Veterans Trust, the Maryland Veterans Commission, and the Maryland Youth Advisory Council. The bill also specifies how representative seats in organizations may be removed from the Maryland Veterans Commission. There are amendments from Senator Simonero on page 30 of your packet. Those amendments are technical and will conform the two bills.
Okay, Senator Simonero, want to move those technical amendments? Okay, Senator Simonero moves the amendments on House Bill 270. Second from Senator Brooks. All in favor of the Simonero amendments, raise your hand. All opposed, amendments carry. House Bill 270 as amended is before us. Senator Simonero, would you like to move the bill as amended? 270 as amended is moved. Second from Senator Brooks. All in favor, House Bill 270 as amended, raise your hand. All opposed, motion carries. House Bill 297, Stacy.
House Bill 297, Adult Education High School Diploma Pathways, Maryland Diploma Works Pathway. This bill is substantially similar to Senate Bill 70 as passed by this committee. This departmental bill establishes the Maryland Diploma Works Pathway within the Maryland Department of Labor to recognize and certify high school diploma achievement through demonstrated academic and career competencies, including workforce experience. The bill also establishes eligibility for participation in the pathway, requires a high school diploma to be awarded to an individual who completes the pathway in accordance with regulations adopted by the Maryland Labor and the State Department of Education. Where the bill differs is in the House, they adopted a provision uncodified that requires the Maryland Department of Labor to publicize the Maryland Diploma Works pathway as specified. Because it's uncodified, it's generally a short-term provision. So the amendment is offered by the chair on page 40 of your packet, limits this reporting requirement to calendar years 2027 and 2028.
Questions for Stacy on the amendment? Okay, Senator Harris moves the amendment. Second from Senator Brooks. Okay, all in favor of the amendment on House Bill 297, raise your hand. All opposed, amendment carries. House Bill 297 is before us. Senator Harris moves the bill, second from Senator Brooks. All in favor, House Bill 297 as amended, raise your hand. All opposed, that motion carries. House Bill 439, Devin.
House Bill 439, Office of the Deaf and Hard of Hearing and Maryland Advisory Council on Deaf of Hard and Hearing, renaming. This bill is a cross-file of Senate Bill 665, which passed the committee unanimously. It renames the Office of Deaf and Hard of Hearing to be the Office of Deaf, Deafblind, and Hard of Hearing. The Maryland Advisory Council on the Deaf and Hard of Hearing is similarly renamed to the Maryland Advisory Council on the Deaf, Deafblind, and Hard of Hearing. The difference between this bill and the Senate bill is that the House added a member of the Department of Disabilities to the Advisory Council, which was not in the Senate bill. There are no amendments.
Okay. Senator Harris moves the
bill.
The bill. There are no amendments. It's the bill. Second from Senator Brooks. Okay, House Bill 439. All in favor, raise your hand on the motion. All opposed. House Bill 439 carries. Next up, House Bill 457, Stacy.
House Bill 457, Institutions of Higher Education Provision of Menstrual Hygiene Products Requirement. This bill requires each institution of higher education that provides on-campus housing to provide free of charge menstrual hygiene products in all student health centers by August 1, 2028. There are no amendments.
Okay, questions for Stacy on House Bill 457? Okay, any motions? Okay, Senator Attar moves the bill, clean. Second from Senator Washington. Discussion? Okay. All in favor of House Bill 457, clean, raise your hand. All opposed? Okay, we have two red votes from Senators Carrozza and Simon-Ayer. But that motion does carry, House Bill 457. Okay, let's go down to House Bill 578, April.
House Bill 578, Fish and Wildlife, Endangered and Threatened Species and Migratory Birds, Regulation, List, Petitions, Essential Habitats, and Takings. This bill makes changes to the state's endangered and threatened species laws and provisions governing the Irreplaceable Natural Areas Program. The bill is nearly identical to Senate Bill 431 as unanimously passed by the committee. The only difference is that the Senate bill includes a provision authorizing DNR to adopt management protocols for designated essential habitats. There are amendments on page 50 of your voting packet with the reprint on page 52. This is being offered by Senator Brooks, who is the sponsor of the Senate crossfile. Senator Brooks' amendment conforms the bill to the Senate bill by adding language authorizing the department to adopt management protocols for designated essential habitats. The amendments also strike changes to the current law regarding takings of wildlife that would have explicitly prohibited a person from taking migratory birds This was, I'm sure everybody saw some emails from NIOP that had concern about the effects of this provision. Through further conversations with the department is confident that they currently have the authority under Section 10-2A-03 of the Natural Resource Article to regulate takings of migratory birds if that does become necessary due to federal changes at the federal level. So their recommendation was to simply take out those changes. However, we're leaving in the provision that has to do with the, again, that was in the Senate version of the bill, also in the House version of the bill, directing the department to basically recreate a depredation permit for black vultures, again, in the event that those protections and changes happen at the federal level, and the department does need to step in to regulate the takings of migratory birds.
Okay, questions for April? Again, we're on House Bill 578. Yes, Senator Attar.
Thank you, Mr. Chair. April, so the amendments relieve the concerns of NIOP now? Do the amendments relieve the concerns of NIOP?
My understanding is that they do.
Okay,
I
thank
up
you.
here, Tom? Okay. Okay. Okay, Senator Washington.
Could you remind us who NIOP is? Is it an
Hey,
environmental
Tom,
group,
since
or what
you
is it?
are representing, tell Senator Washington exactly what NAOP is.
Committee staff could tell us.
The acronym used to stand for the National Association of Industrial and Office Properties. We represent commercial real estate companies that are involved in office, mixed use, and some warehouse distribution kinds of projects across the state.
And forgive me, perhaps I wasn't here for the hearing. What was the concern about that provision?
The concern was not at the hearing. In the voting session, there was an amendment that prohibited the incidental take of migratory birds. So that's the unintentional harm to migratory birds. And given the way that the definition of harm is also changed by the bill, there was some question about how it would apply to habitat impacts during land development and construction. Also, what would happen with existing buildings if there were migratory bird collisions with buildings.
So this is a permitting issue? Would you say their concern is the impact on their ability to build on habitats?
No, so
I'm trying to understand.
my understanding, because the way the bill was written, it just said it flat out prohibited the taking, including incidental takes of migratory birds. The purpose of this bill has always been to allow DNR to sort of step into the shoes of what the federal government has been doing. But the way the federal government has regulated incidental takes of migratory birds is much more nuanced than just a blanket prohibition on incidental takes. There's lots of regulations involved with that. So again, the department believes that under their current authority, if they need to, they can recreate those regulations. The concern was, though, just a blanket prohibition without the nuance of those regulations could sweep up construction activity that would currently be authorized both under federal and state law.
I understand. And so I just want to bring to the attention that we've relied traditionally, I guess, on federal enforcement. And so far, every attempt that we make on these types of protections of lands is opposed by our development community. So we're going to have to come to some sort of understanding that we're in a situation that requires us to reinforce our environmental laws because there's nothing on the federal level. But what you're saying is that DNR feels they already have this authority, so this provision is not needed. Okay, all right, thank you.
Okay, so we have an amendment. Okay, further questions on the amendment? Yes, Senator Cardoza.
Does the amendment address any of the issues raised by the Maryland Farm Bureau? They had a letter of information, and then I was trying to understand if the amendment was not on the
Tom,
House bill?
you're good. Unless you're all of a sudden part of the Maryland Farm Bureau, we're good.
So the Maryland Farm Bureau, again, came in, so their concerns were already addressed both in the House and in the Senate. Theirs was about that black vulture depredation permit issues. That is in this bill, it's in the Senate bill. Their concerns have been addressed.
Okay, and so this amendment, I guess, can we just clarify what this amendment does? And it was, this is just for this bill, it wasn't, it's just coming over to us now, the amendment for this bill?
So the bill as it came over from the House is nearly identical to the bill that we sent over.
Okay,
But NAIOP came in with a sort of, based off of amendments that were added in both the House and the Senate, some concerns about the migratory bird takings
Right.
provision. So this amendment addresses their concerns, but it does not touch the amendment that was already added to address the Farm Bureau concerns around the black vulture
Thank you.
depredation permit.
Okay. Okay, we have an amendment before us, and there was a motion, second from Senator Harris, just on the amendment from Senator Brooks. House Bill 576, as, all in favor of the, I'm sorry, 578 on the amendment, raise your hand.
I understand.
All opposed, one opposition from Senator Washington. Oh, I'm sorry, you're for it? Okay, that motion carries unanimously. We now have House Bill 578 as amended. Senator Brooks moves the bill, Senator Harris seconds. All in favor of Senate Bill 578 as amended, raise your hand. All opposed, motion carries. Let's go down to House Bill 635. We're just going to go another maybe 15 minutes, and then we're going to
House Bill 635, Child Care Facilities Criminal History Records Check Requirement. This bill requires individuals who will have direct contact with children in specified child care facilities to submit to a criminal history records check in accordance with current statutory provisions under the Family Law Article. The Maryland State Department of Education must establish a centralized unit for the processing and management of information about criminal history records checks on or before June 30th, 2027. The bill also alters statutory provisions requiring MSD to establish probationary employment qualifications for first-time child care teachers in a child care center that serves preschool or school-aged children. The bill also repeals the limitation on the number of deputy state superintendent of schools that may be appointed. Finally, the bill requires MSDE to conduct a review of the process for the background checks as established by the requirements of the bill to evaluate the efficiency and timeliness of processing applications and to identify opportunities for improvement and to submit a report to the Maryland General Assembly on or before October 1, 2028 of specified information. This is a cross-file to Senate Bill 359. The differences are the definition of child care facilities, the notification to the application. In the Senate bill says within 45 days after submission. In the House bill, it says in the time frame required under federal law. And the House added a study and a report. I will say that federal law is 45 days, so it's kind of a here or there question, but MSDE, after talking with them, because the House has indicated they will not pass a bill without the study and the report, that they prefer the House version of the bill, and they think this is an important bill. And so no amendments have been offered, and the motion would be to pass it clean.
Okay, Senator Caruso moves the bill clean, House Bill 635. Is there a second? Second from Senator Tarr. Discussion? All in favor, House Bill 635, clean, raise your hand. All opposed, motion carries. Okay, let's go to page 3. Devin, let's get to you here.
House Bill 648, excuse me, Office of Home Energy Programs, Uniform Redetermination Process Age. This departmental bill reduces the age from 65 to 60 years old, for which the Office of Home Energy Programs must develop a uniform redetermination process to assist eligible energy customers in enrolling in energy assistance programs. The bill takes effect July 1, 2026.
Okay, no amendments?
No amendments, sorry.
Okay, any questions? Okay, Senator Brooks moves the bill. Senator Harris is a second. Discussion? All in favor, House Bill 648, raise your hand. All opposed, motion carries. Devin, House Bill 721.
House Bill 721, Uniform Services Spouses Act. This bill is a cross-file to Senate Bill 243, which passed the committee unanimously and is identical to the Senate version as it passed the Senate. It expands spousal eligibility for priority registrations for veteran services at community colleges, for senatorial and delegate scholarships, for hiring and promotion preferences relating to veterans, and for credits on selection tests for applicants of specified state and local employee positions. There are no amendments. I missed it for the concurrence
Okay,
calendar.
this could have been a, okay, so it's identical to SB 243. We already passed unanimously. Okay, Senator Harris moves it. Senator Carrozza second. All in favor, House Bill 721. Clean, raise your hand. All opposed, motion carries. Devin, House Bill 861.
Similarly, I missed this one as well. House Bill 861, Department of Information Technology, Statewide Information Technology Master Plan Reporting. This bill is the cross-file to Senate Bill 581, which passed the committee unanimously and is identical to the Senate version as it passed the Senate. It requires the Secretary of Information Technology to post the Statewide Information Technology Master Plan publicly on the Department of Information Technology's website within 1 year after the date the governor is inaugurated in each gubernatorial term. If the Secretary is unable to meet the deadline, the Secretary must notify the governor in writing and specified committees of the General Assembly within 10 days after the missed deadline. And finally, the bill requires the department to brief the General Assembly on the plan each year. There are no amendments.
Okay. Okay, Senator Harris moves the bill. Second, Senator Carrozza. All in favor, House Bill
861.
861, raise your hand. All opposed? That motion carries. Okay, next up, April. We're on
House Bill
House Bill 969.
House Bill 969, electric vehicle fuel sold at retail, equipment requirements, units of measure, and fees. This bill, under provisions governing the regulation of any instrument or device used for weighing or measuring, weights and measures, requires the owner or possessor of a weight and measure used for the retail sale of electricity as vehicle fuel to clearly and conspicuously display information detailing the name, address, and phone number of a local person responsible for the weight and measure. Information may be displayed on or immediately adjacent to the weight and measure. All electricity possessed, offered, or exposed for sale and sold at retail as vehicle fuel must be measured and sold in units of kilowatt hours. During a charging session, a customer may be charged only for kilowatt hours of electricity dispensed during the charging session. In addition to the price charged for the retail sale of electricity as a vehicle fuel, the owner or possessor may charge a fee for services related to the retail sale of electricity, which one may be a fixed fee or assessed based on length of time, 2 may be applied only at the conclusion of a charging session, and 3 must be itemized on the customer's receipt. This is the cross-file of a bill that was heard in this committee, it's identical, but was not actually cross-filed to a bill that was heard in this committee, but not moved. There are no amendments.
Okay, any questions for April, again, on House Bill 969? Okay, Senator Harris moves the bill, clean. Senator Brooks, second. All in favor, House Bill 969, raise your hand. Opposed, motion carries. Let's go, one opposition from Senator Carrozza. Okay, House Bill 1164 at the bottom.
House Bill
No, we already done that.
1164, water companies, sewage disposal companies, and water and sewage disposal companies' limited income mechanisms. This bill requires the Public Service Commission to study the feasibility of requiring water companies, sewage disposal companies, and water and sewage disposal companies to adopt limited income mechanisms to benefit eligible limited income customers. By December 1st, 2026, the Public Service Commission must report its findings to the Governor and the General Assembly. Beginning July 1st, 2027, the bill applies existing statutory provisions governing limited income mechanisms to water companies, sewage disposal companies, and water and sewage disposal companies by modifying the definition of utility company. There is an amendment in your voting packet on page 87. The reprint starts on page 88. This was an amendment requested by the Public Service Commission, and it's my understanding that the bill sponsor, Delegate Foley, is in agreement with this amendment. But instead of expanding the definition of utility company, which would have unintended consequences, this would instead authorize the Public Service Commission to require a water company, sewage disposal company, or water and sewage disposal company to adopt limited income mechanisms as specified.
Okay, the vice chair moves that amendment. Second? Second. Senator Harris, second. Discussion? Okay, all in favor of that amendment, raise your hand. All opposed? Amendment carries. We have House Bill 1164 as amended in front of us. Okay, Senator Harris moves the bill, second from Senator Brooks. Okay, all in favor of House Bill 1164 as amended, raise your hand. Anybody opposed? Motion carries. Let's go.
Just quickly,
Yeah.
that one is cross-filed. Senator Gallion had the cross-file. Would you like to
Yeah,
move that
let's-
as well?
Okay, is everybody good
Senate Bill 556.
conforming what we just did to Senate Bill 556 from Senator Gallion and the amendments and everything? And then, again, all in favor of doing that, and then everybody's vote will count the same? Okay, so we're doing that for Senator Gallion. Okay, let's go to page 4. And we're going to start with House Bill 1196.
House Bill 1196, Environment Water Quality Testing Secondary Maximum Contaminant Levels Action Plan. People have asked on multiple bills whether we were talking about the jars of the dirty water. This is the jars of dirty water bill. This bill requires the Maryland Department of the Environment to develop an action plan for the enforcement of standards for secondary maximum contaminant levels to address water discoloring, taste, and odor at community water systems and non-transient, non-community water systems as specified. The department must consult with specified stakeholders and by December 1st, 2026, report its findings and recommendations to the General Assembly. There are no amendments.
Okay, any questions? No amendments? Motions? Okay, the vice chair moves favorable, second from Senator Brooks. All in favor, House Bill 1196, raise your hand. Opposed? Motion carries. Let's go down
And
next.
just quickly, so that
Oh,
one,
yes.
again, we have not moved the Senate cross-file yet. Senate Bill 940 is,
Okay, let's move to conform to Senate Bill 940. And everybody okay with 940, same posture? All raise your hand, support of that? Okay, so Senate Bill 940 will move forward as well. Let's go down to House Bill 1267. April?
House Bill 1267, Patuxent Research Refuge in Beltsville Agricultural Research Center zoning classification, protecting Patuxent Research Refuge Act. This bill establishes land use provisions relating to the Patuxent Research Refuge and the Beltsville Agricultural Research Center that, one, require the land of the refuge and center to be maintained in specified zoning classification and land uses, and two, protect specified central natural areas within the refuge and center. There are no amendments.
Okay, we have a motion from Senator Harris. House Bill 1267, second from Senator Brooks. Discussion? Okay, all in favor of House Bill 1267 clean, raise your hand. Opposed, motion carries. House Bill 1300, Devin? Oh, I'm sorry.
Real quick, I missed it. So the House Bill 969, electric vehicle fuel sold at retail, then we also have a Senate bill. Did we do both of those?
You know what, I cannot remember. Did we do
There's a Senate Bill 649.
649? It's on the list.
Is it the same bill?
It is the same bill. It's not technically cross-filed, but it is the same bill. So would you like to move? I can't remember if we moved Senate Bill 649 yet.
Yeah, if you look at the, 649, I guess not a technical cross, also we didn't see that, but is that the Allen, which bill?
It is,
69.
right, it is identical to,
The Allen bill,
649?
page B 969.
Sorry to jack us up.
No, it's good. Well, the reason it's not a technical cross, so they weren't right next to each other, but if you go on page 5 at the end, we do have that bill, so we should really.
969.
Yeah, okay, so what was the House bill we moved?
So it's House Bill 969, Senate Bill 649
Okay.
is the companion bill, we'll say.
Okay.
It was not cross-filed.
Okay, well, let's go over to, let's just take care of that. Senate Bill 649, that Senator Harris is in the same posture as the.
It will need to be amended to be in the same
When,
posture.
everybody okay conforming?
I voted against.
Okay, well, everybody's vote will count the same, and we're going to conform 649 with 969 with the one reflected that Senator Carrozza's a no vote, okay? So everybody's okay with that? Raise your hand if you agree with that, doing that, okay? Okay, let's go back to, we were at House Bill 1300 back on number 4. House Bill 1300, Deb?
House Bill 1300, Maryland Commission for Women, alterations. This bill alters the duties of the Maryland Commission for Women. It removes the requirement that the executive director of the commission be appointed by the Secretary of Human Services, and instead specifies that the executive director is not considered a special appointee and is in the skilled service in the state personnel management system. There are no amendments.
Okay, Senator Washington moves the bill clean, second from the vice chair. Discussion. Okay, all in favor of House Bill 1300, raise your hand. Opposed, motion carries. Let's see if we can just finish up, grind through 4 more bills. House Bill 1466, April.
House Bill 1466, Department of Housing and Community Development, appraisal gap from historic redlining financial assistance program, qualified properties. This bill expands the definition of a qualified property under the appraisal gap from historic redlining financial assistance program to include residential real property that is in an area that meets criteria established by DHCD for the identification of neighborhoods that have been historically redlined or have undergone urban renewal. There are no amendments.
Okay, the vice chair moves favorable on House Bill 1466 from Delegate Wims. The second from Senator Harris. Discussion. Okay, all in favor, House Bill 1466, raise your hand. Opposed? Motion carries. Okay, Stacy, House Bill 1448.
House Bill 1448, Municipal Elections, Reporting of Information to the State Board. This bill is substantially similar to Senate Bill 848 as passed by this committee. The bill requires a municipality to submit to the State Board of Elections at least 3 months before the candidate filing deadline for a regular municipal election the qualifications to be a candidate for each office on the municipal ballot. For a special municipal election, the municipality must report to the State Board of Elections within 10 business days after the election is scheduled, the election date, each office on the special election ballot, and the qualifications to be a candidate for each office on the ballot. The bill also requires a municipality to submit to the State Board within 10 business days after the candidate filing deadline for a municipal election, including a special election, a list of each qualified candidate for each office on the ballot. And here's where they differ. And if the election is a partisan election, the party affiliation of each candidate, and information on how to vote and where to vote. SB must publish each submission on its website immediately after it's submitted. The amendments for the Senate bill just accidentally omitted that partisan language, so it was meant to be there. There are no amendments.
Vice Chair Kagan?
Thank you, Mr. Chair. Police Subcommittee, Election Subcommittee just voted amendments to this bill today, like an hour or so ago, and so I think they haven't made their way over to the Senate, but I just wanted to let you know that Delegate Tomlinson and I and MML and Senator Gallion and stuff have been working on this, and we're all aligned, but there are amendments, so I'm going to ask that we hold the bill till tomorrow.
Okay.
Is that all right, Stacy?
Yeah.
Okay.
Carosa, you good with that? We're good? Hold that until tomorrow, which brings us to our final bill of today.
Okay.
Delegate Warman.
House Bill 1530, Higher Education Undocumented Students Out-of-State Tuition Exemption Eligibility. This bill reduces the number of years from 3 to 2 for which an individual or an individual's parent or guardian must file a Maryland income tax return prior to the academic year in order to qualify for an exemption from paying out-of-state tuition rate under the Maryland DREAM Act. There are no amendments.
Okay, no amendments. Any questions on House Bill 1530? Senator Harris, questions?
Real quick, so this, for council, does this bill apply to both in-state tuition eligibility and financial aid eligibility, or just in-state eligibility?
Just in-state eligibility.
And then, okay. So what do we need to do if we needed that for financial aid eligibility? It didn't talk about that at all in this bill.
It did not, no.
You want to hold it? What would you like to do?
Yeah, just hold
Okay.
it.
Okay, let's hold House Bill 1530. And with that, that's going to complete our work for today. And that was a lot of bills. And I want to thank everybody for sticking it out, toughing it out. And so I hereby declare this voting session complete.